data practices.
Did you start? I just got it. Did you start that audio? It is started.
Okay. I'll call the Data Practices Subcommittee to order. First of all, first order of business is approving the minutes from April 26, 2011. Anyone like to move those minutes? So moved. Thank you. What? All those in favor of moving the minutes, approving the minutes, say aye. Aye. Opposed, same. Minutes are approved. First on our docket, we have Representative Cornish and House File 2160. Representative Cornish, what are we moving? Are we moving this through?
We're going to
Okay. Okay, we're going to recommend that this bill be passed and moved on to the full Civil Law Committee. Would someone here like to move the bill for Representative Cornish? Oh, I'll move it. I'll move House File 2160. Please go ahead.
Madam Chair and members, House File 2160 tries to fix a problem that I've been aware of for a number of years when I sat on the CrimNet board called Records in Suspense. And what happens is that the fingerprints don't get linked up with the record, and it messes the whole system up and puts the records in suspense, and it's hard to get them reconciled. You're allowed right now in law enforcement to fingerprint people for certain offenses, and that's good, but there's sometimes when somebody leaves from court and doesn't go to get booked or fingerprinted, and it causes the records to go in suspense, and other reasons why that happens. And fingerprints are taken for certain offenses. This bill would enlarge that to other offenses, as you notice on the back of the bill on line 2.4. This entire bill consists of a change in existing language from the offenses in suspense to any offense. And displaying the technicalities here, Madam Chair and members, I have Kate Engler, the senior legal analyst from the Bureau of Criminal Apprehension, to go through the bill, if you could.
Okay, Ms. Engler, go ahead and state your name for the record and proceed.
Thank you, Madam Chair. My name is Katie Engler. I'm with the Bureau of Criminal Apprehension. Representative Cornish is correct. Current law requires that when an individual is arrested or charged with a felony, a gross misdemeanor, or what you have called targeted misdemeanors, their fingerprints are supposed to be taken. And fingerprints are the way that the Bureau links records together so that we know an individual's hopefully complete criminal history. And this is important because individuals don't always use the same name when they identify themselves to law enforcement. There is a crime of identity theft, so they are intentionally using someone else's identity. And so the fingerprint is the way that we use to make sure that all of the records that belong to a single individual are in fact associated with that individual's record. So we had some testimony at the public safety hearing about fingerprints, and specifically the testimony was that fingerprints change over time. And I have to confess that caused quite a bit of consternation amongst the forensic scientists who work with fingerprints at the Bureau. They were very emphatic with me that fingerprints, because they exist in the base of our skin, the patterns do not change over time. How easy it is to see those patterns may change if you've gotten your skin dehydrated, or you've done something where you've rubbed the outer layer of skin off your fingertips. But if you cease those detrimental activities, the ridges in your fingerprints come back and the patterns do not change. We do know then, based on those fingerprints, that an individual who had a particular offense in the past can be linked with other offenses using those fingerprint records. As Representative Cornish indicated, most fingerprints are taken at the time of arrest and booking. However, some individuals are not arrested. Rather, they are charged via complaint. And then you've provided a number of different tools to try to get people to provide those fingerprints as part of the process. What this bill does is it provides one additional tool for criminal justice to use in order to resolve fingerprints in suspense. And specifically, the language says right now that the suspense record can only be resolved when the individual is in the criminal justice system for the record in suspense. The change would allow criminal justice to resolve that suspense record if the individual came back into the criminal justice system for another offense. So a little bit of history. About 10 years ago, you set a goal of getting the number of suspense records below 10% of the total, and that goal was achieved in March of 2010 and has been maintained. We are asking for this additional tool, as I said, so that when a law enforcement agency or another criminal justice agency determines, based on data that they have, that the individual is back in the criminal justice system and they have that record in suspense, that the fingerprints can be obtained and that the suspense record resolved, thereby completing that individual's criminal history. This can be important for purposes of a prosecutor determining whether or not to request enhanced penalties or charges against an individual for the subsequent offense, and also can have an impact on the pre-sentence investigation. So it's important that we have this additional tool for criminal justice to use to help resolve these issues. We were asked at the last hearing, how does criminal justice know that they have the right individual? Well, they compare different items of data between the record that's in suspense and their own case file. They compare photographs. They use scars, marks, and tattoos. They make sure that the offense that is in suspense is the offense that, in fact, they charged the individual with in the past. And so they use these pieces of data to determine that they are asking the correct person to be fingerprinted. And in fact, we had some discussion since the last hearing about what the Bureau could do to help indicate to law enforcement and other criminal justice agencies that the steps that they take to do this identification should be documented. We offered that we would modify our training program and on our suspense prevention website provide information that would indicate the best practice would be to document how the particular individual was determined to be the person whose record was in suspense. The final question from the Public Safety Committee meeting was about the fact that there are devices that law enforcement can use. It's called a two-finger rapid ID. It's a little scanner that they have in their squad car. And the question was whether or not the fingerprint that was captured by that device could be used to resolve the suspense record. The answer is it cannot. It is merely a screening device that is, or screening tool that's used to identify someone to determine whether or not they already have fingerprints on file. There is no capture mechanism for that particular device. So, as Representative Cornish explained, this really is a change to provide an additional tool to criminal justice in order to resolve the records that are in suspense. And with that, I'll be happy to answer any questions.
Thank you, Ms. Engler. Representative Lesh.
Thank you, Madam Chair. Ms. Engler, it provides an additional tool for law enforcement to link up these suspense records to people who are identified in the system. Does it require the law enforcement to use that tool? And if so, are there any costs associated with the additional work that law enforcement will have to do in order to perform those checks and match up the records?
Ms. Engler.
Madam Chair, Representative, there are currently obligations in the statute to law enforcement, also to prosecutors and the courts, to work to ensure that for felonies, gross misdemeanors, and the targeted misdemeanors, that fingerprints are obtained. So I don't believe there really is any change in the level of effort that law enforcement or courts or prosecutors are being asked to expend. It's just providing another period of time during which an individual suspense record can be resolved.
Okay.
Representative Lesh.
Thank you, Madam Chair. I appreciate that answer, Ms. Engler, but now I thought I understood it, and now maybe I don't understand it based on that answer, because I thought we were saying that law enforcement before they're obligated to do this, but the statute blocked them because it wasn't on a list of targeted misdemeanors. And now we're saying there is no list, it's everything, so law enforcement will be required under those other laws you spoke of to do this work. Am I correct?
Ms. Engler?
Madam Chair, Representative, I think you and I are not communicating in the same way. In the same provision that's being amended is the requirement, in fact, it's on page 1, starting in line 1.9, for fingerprints to already be obtained. The change on page 2 in line 4 is rather than limiting resolution of the suspense record to the period of time where the individual is participating in the criminal justice system for the record that is in suspense, that this broadens it so that if they are subsequently interacting with the criminal justice system for another offense, that the previous record in suspense can be resolved.
Representative Cornish, I think, wanted to add a comment.
In kind of layman's terms, to make it simpler, if somebody goes through the system and for some reason the fingerprints aren't captured like they should have been for all the different offenses, that record will go into suspense and it'll get messed up. If sometime that person gets involved in the criminal justice system again in the future and is brought in, they look up his name, date of birth, and find out the records in suspense, this would allow them to take the fingerprints to match up to fix the record. So that's all it is.
Okay.
Representative Lesh?
Thank you, Madam Chair. And specifically, in this case, it would be if you had a previous assault, let's say, fifth-degree assault, which is on the list of targeted misdemeanors for taking fingerprints, and then you get a subsequent offense for, I don't know, I think basic theft is on it. Maybe I'm not right, but I don't think basic theft, like shoplifting, is on the list of targeted misdemeanors. So you get a subsequent charge of shoplifting, and if you want to use that other charge to enhance it, you can find it now because we're required to fingerprint on that shoplifting, right?
Ms. Engler?
Madam Chair, Representative Lesh, an agency may choose to fingerprint for the shoplifting. If it's not on the list of targeted misdemeanors, they're not required to. But if as part of their case preparation for the shoplifting, they see that previous offense and the fingerprints are missing, they then have the opportunity under the change to obtain the fingerprints, associate them with the prior record in suspense, and then have it available for enhancement.
Okay, thank you. So final question then, Madam Chair. I think it is then, you said have the opportunity, so it's not required that you have to fingerprint for that subsequent shoplifting. You are allowed to now. Am I right?
Madam Chair, Representative, that's correct.
Okay, thank you.
Representative Simon?
Thank you, Madam Chair. Quick question. Ms. Engler, you mentioned a little bit ago that we've gotten below the 10% threshold on cases in suspense. Where are we now in terms of percentages or even raw numbers, if you have kind of a ballpark estimate?
Ms. Engler?
Madam Chair, Representative, the cumulative number of records in suspense at the end of January 2012 is 165,499.
And Madam Chair,
Representative Simon?
yeah, Ms. Engler, what percentage is that, roughly, within a range?
Ms. Engler?
Madam Chair, Representative, based on the information from our website, the percentage of dispositions that went into suspense in January of 2012 was 8.47%.
Thanks.
Other questions? Representative Holberg?
Thank you, Madam Chair. Ms. Engler, so who is going to get fingerprinted if this bill goes into effect that you weren't able to fingerprint already?
Ms. Engler?
Madam Chair, Representative, nobody knew it would be to resolve a record for which there already is a fingerprint requirement. It's a question of timing. So if they already were required to be fingerprinted for a felony, a gross misdemeanor, or a targeted misdemeanor, but that didn't happen while they were interacting with the criminal justice system for that offense, if they were to come back into the criminal justice system on a new offense and they could link the person with the old record, they could then take fingerprints and resolve that old record.
Representative Holberg.
And so, I mean, I'm looking at how the paragraph's laid out, and it's not entirely clear to me, because if you get farther down, there's latitude, where you say in lines 2.6 and 2.7, in order to maintain and ensure the accuracy of the Bureau's criminal history files. So could this change not be construed to mean that you could, where's the safety net, if you will, to make sure that that standard isn't used to expand who gets fingerprinted?
Ms. Engler.
Madam Chair, Representative, I think the safety net is on page 1 in lines 1.15 and 1.16, where it says for what offenses the fingerprints are to be taken. Felony, gross misdemeanor, or targeted misdemeanor.
Representative Holberg.
Right, but then, I'm sorry, Madam Chair, Ms. Engler, but then you get to number 7 is equally as important as 1 through 6. I'm not arguing with what you're trying to do. I just don't like loopholes, and I'm just not sure that how you've chosen to do this in that paragraph with all that other latitude is the right way to do it.
Representative Cornish.
Madam Chair and Representative Holberg, I see what you're talking about, but it seems like there's two places where it gives protection that only people are going to be fingerprinted are the people that should have been fingerprinted in the first place, and they're just catching them later, because 2.6 and 2.7, when it refers back to whose fingerprints are necessary in order to maintain, the only ones that would really be necessary would be the targeted offenses and targeted misdemeanors. So I wouldn't think it's going to be for any new offense or drag anybody new unless the law enforcement agency is going to do that voluntarily. Right now, they're only required to do it on a certain number of offenses, but I wouldn't think this would be any additional people that would be fingerprinted, just to be the ones that are missing from the targeted list, and they're caught later when they come into the system again.
Okay, if I might maybe...
Yes, Representative Holberg.
Madam Chair and Representative Cornish, what if the BCA gets a great new idea and they say, well, in order to maintain and ensure the accuracy of our criminal history files, we're going to take fingerprints on any offense to weed people out, if you will, to make sure that they're not involved with a suspended file. What stops that?
Either one of the testifiers want to tackle that one?
Well, under this, Madam Chair and Representative Holberg, under this bill here, I think all that would be allowed is if they come into the system again, like the person is picked up for any offense and is brought in, and then the name and date of birth indicate that he or she should have been fingerprinted for the targeted offense. And that's the only thing that would cause them to be in suspense, would be if they missed a fingerprinting for a targeted offense. So I don't think they would drag anybody new into this, or could use this to drag people new, like bring people in off the street. It'd have to be for an offense, and then the record would have to be in suspense from a previous targeted. So I wouldn't imagine how they could use this to carte blanche cleaning the records up.
Representative Holberg.
But you could answer that better.
This is going out of here today, is that the
The Civil
plan?
Law Full Committee.
All right. Thanks.
I might suggest that maybe they could work on language or clear up the difficulty in between here and the civil law, and
Okay.
hopefully. And
Did that work for you, Representative Holberg?
That's fine.
All right. Ms. Engler, did you have another comment?
Thank you, Madam Chair. Well, I'm looking at the language on 2.5 and 2.6, which talks about a record which cannot be linked to an arrest record and whose fingerprints are necessary. So if there is, to me, the "and" requires both of those clauses. So the scenario that Representative Holberg presented of capturing fingerprints in order to prove a negative, in essence, to say someone does not have a record, would not fit here because the clause about being linked to an arrest record would fail.
Right, thank you.
All right, thank you. I believe we have Rich Newmeister is here to testify. If the other two testifiers would just stay at the table, that would be great. If the page could get Mr. Newmeister a chair, please. Or he can get one himself, I guess. State your name for the record, please.
Madam Chair, for the record, my name is Rich Newmeister, and members of the subcommittee. I testified when this was in the previous committee, and the BC has addressed one of my concerns. I brought up the issue of the two fingerprint thing that's now part of many law enforcement agencies. Just to also let you know, I come with a background of working with the BCA and Mr. Cornish over the last 16 years, because a lot of these issues have been on the Criminal Justice Information Task Force, and I am a citizen member of that committee for the length and the history of that, and currently. The issue for me was been talked about a little bit here. One, again, it goes back to 2.3 and 2.4, and the change of any offense. Currently, many law enforcement agencies will fingerprint almost everybody that comes in. It can be from misdemeanors, petty misdemeanors, or whatever. I mean, because you got to remember that you as the legislature funded, it's no longer the ink type things. It's what they call AFIs. You just put the prints on like this, and they go up real fast. So the technology has allowed now law enforcement to do a lot more in a faster kind of way. So one of the concerns I have is, let's say, for example, if you go back over to on page 1 on 20, a young person gets in trouble at home a little bit, creating a ruckus, disorderly conduct, or parents call the police. I'm having trouble with my young person here. And they bring them to the detention center, and as you can see, they're fingerprinted. That is not necessarily could be a targeted misdemeanor or a felony or a gross misdemeanor. It could be, they take them home for, remove them for the night or whatever to a detention center. One of the concerns I have is that with all those fingerprints that are not done under the current law, which is targeted, gross misdemeanors, and felonies, you're going to get a bunch of other ones. And now these are going to be used for trying to tie into suspense. So it says where there's any offense. So any offense can be one of the things that they may do now currently with the ease of how it is to get fingerprints. I illustrate it again as an example with the young person going to a juvenile detention center. And a lot of those sometimes are not necessarily a targeted misdemeanor, felony, or gross misdemeanors. So that's my point. I would rather suggest that it could only be used for targeted, or currently what the misdemeanors are, not for any offense. That's my point, and that's at least some of the discussion that whether that might be language that may help as it goes from here to civil, I don't know. But that's a concern that I have.
All right. Question?
And then, Madam Chair, and also then, again, it's one of those things, when a bill comes up, sometimes you don't think of issues until the bill comes up, because there are so many, at least, that I deal with. And then I wonder, well, then what happens to all those fingerprints that are being collected outside of the, what's now currently listed by law? But that's another question, but it raises some issues.
All right.
Thank you.
Questions for the testifier? Anybody? Thank you, Mr. Newmeister. Next on the docket, Carolyn Jackson. Welcome to the committee, and go ahead and state your name.
Thank you, Madam Chair. My name is Carolyn Jackson. I'm the lobbying coordinator for the ACLU of Minnesota. Now, the BCA has been very generous in responding to the concerns that we raised in public safety about due process and about fingerprints. What I present to you is a policy question. Linking somebody's fingerprints with their file has very serious consequences that if there was a mistake made, it is akin to being tried and found guilty without any due process of law. So once your fingerprint gets linked to one of these criminal justice files, it's a biomarker. You're permanently linked to that. And the question that I have for the committee is whether the safeguards in place are sufficient to make sure that that is done accurately, because the consequences are very serious. To get that cleaned up would be hours and hours of legal work and a very expensive undertaking for a person trying to clear up the record if a mistake was made. Ms. Engler testified that the BCA will document the steps that need to be taken. They'll teach that in their training of officers, and on their website list that as best practices. The point I have is that the BCA has a list of steps to take to make sure that mistakes aren't made, including when the fingerprint is taken at a later date, that that's the date that's put on it, and then it's put back in the file. So the offense may have happened in 2002, the print taken in 2012, and the date associated with the print would be 2012, not 2002. The question is, it's not the BCA that's taking these prints. It is the local officer. And the question for you is whether the steps that the BCA lays out as best practices are sufficient to ensure that these mistakes aren't made, and if they are made, that there's sufficient recourse for a person who eventually finds out those aren't my print, or that I wasn't guilty to that offense. Somehow or other it got garbled, and another Carolyn Jackson did that, and just to make sure that that's sufficient due process.
Thank you for your testimony. Representative Lesh has a question.
Thank you, Madam Chair. Ms. Engler, can you tell me, now I have experience where I get a tag back and I need to match up prints, and it's the state's obligation to prove guilt, so I have to send it over to the BCA, send it to the lab. I get someone saying, yep, that looks like the swirl there, that's pretty much the guy. Now, at that point, I still have to prove it, right, in court. So in a lot of those times, if I have to do the extra work of proving it, and I've got some other files on the guy, like a theft and domestic assault or something, I usually drop those ones where I have to do extra work to do the identification if it's not a major deal anyway, and that's part of the plea deal where I drop those. What percentage of these new cases now that we could do under this law change will be cases where the state still has to prove guilt versus cases where it happened like it was testified to 5 years ago, and all of a sudden, I mean, is that what we're talking about here? All of a sudden I find out that I've got an additional assault on my record, and I say, no, that wasn't me, but someone said my fingerprints look like it. What's the percentage breakdown between those that are still in the justice system before a disposition and those post-disposition?
Ms. Engler, you have an idea on that number?
Madam Chair, Representative, I have to do some research for you. The bill is geared towards an individual whose record is in suspense because the court disposition, meaning the finding of guilt or not guilty, cannot be associated with the arrest record. So I'll have to go back and ask if they can tell me the difference between, if there's a difference in the percentages.
Okay.
Representative Lesh.
And maybe that's not even possible. I don't know if that ends up in there. I mean, if it's impossible for there to be a disposition if it's not associated with an arrest, because I actually would have to prove that, and I assume that during that process of a trial or a plea, it would get associated that way. But I realize it's Saturday afternoon, but it's still Monday, so my brain's not moving fast. So if that is the case, to me that's a very different question. If I still have to prove it as the government, obviously there's more due process protections. But if we're talking about people after the fact, actually finding out, wait a second, I was never even there, and all of a sudden my record's associated with it, that would be a big deal. So,
Any other comments from the testifiers or more questions for the testifiers? Thank you for that. Further discussion by the committee members to House File 2160? If not, I will renew my motion to pass House File 2160 and refer it on to the full Civil Law Committee. I think in the meantime, if you could touch base with Representative Holberg and work on some of the language, some of the concerns that were raised here today, I think that would be great. All those in favor of passage of House File 2160 and moving it on to civil law, please signify by saying aye.
Aye.
Opposed, nay. The file is passed on to civil law. Thank you
Thank you,
very
Madam
much.
Chair and members.
Next item on our agenda is House File 2201, Representative Scott's bill. I see you have a delete all amendment. I'm assuming you'd like to move that to get the bill in the shape you'd like to discuss.
Yes, Madam Chair.
Representative Scott moves approval of the DE1 amendment. Any questions? Seeing none, all those in favor say aye. Aye. Opposed, nay. Amendment's adopted.
Members and Madam Chair, this is a department bill that I submitted, and we realize there's some work yet to be done on it. All the participating stakeholders have been talking. I know this committee meeting kind of snuck up on us. Perhaps there should have been a little more time allowed. But anyway, we'll proceed from here. We'll hear from the administration and our testifiers, and we're very open to the word from the committee here.
And if I might, it's my understanding that this will be laid over, and there'll be an opportunity for another subcommittee meeting to kind of iron out any of the details or lumps or bumps.
Right, that's
Bill.
correct, Madam Chair.
All right, thank you. Welcome to the committee, Ms. Vire-Kabinski.
Good afternoon, Madam Chair. I'm Lori Barkopensky, Director of Community Services, which includes the Information Policy Analysis Division of the Department of Administration. IPAD's mission is to promote understanding and compliance with the Data Practices Act and the Open Meeting Law. And since these laws are meant to be used and understood by normal, regular citizens, our goal is to help make the law work better. We leave the policy decisions to you. We try and raise some of them, but the policy decision is up to you. As Representative Scott mentioned, this is a department bill. The ideas for this bill come from customer feedback, including advisory opinions that have been issued by the Commissioner of Administration. We get lots of calls from folks, and we take those calls. We love getting calls from customers. We're a small division, so it's always great that people know us and find us for resources. But we take those calls as an indication of confusion. So a lot of the calls that we've gotten, we've kind of wrapped them into this bill to try and simplify it. As many of you hopefully know, our customers include both state and local government attorneys, but as well as citizens, media, legislators, your legislative staff. So we hear from thousands of people each year with their questions about various provisions. So we've been working hard to get as much feedback on this bill as possible. Admin held a stakeholder meeting in December. We also participated in MinCoG, who I believe you'll hear from later. They had a session in January. We also, before the bill was introduced, we released the language in January to our listserv of over 900 people. So we've been actively trying to get feedback from folks. We also had 2 focus groups of our customers in January to kind of hear from them as well. So based on the feedback that we've heard, we removed a number of the proposed changes to the Tennyson warning and altered the language around data challenges and removed one of the proposed provisions to protect the identity of people who complain about appointed officials. So even before the bill was introduced, we pulled back based on feedback. And in addition, this delete all does not contain the 6-month exception around making a request for copies of public data that you've already made a copy request for before. It also does not include the protection for identities of people who complain about government employees. So that has also been removed. There are also a number of the provisions going throughout the delete all that have been tweaked a little bit based on feedback, and I'll highlight that as we go along. So now I'd like to walk through the DE1 summary that you were provided. The biggest thing that makes this a lengthy bill, and from our customer feedbacks, they were really concerned about things being not clear. They didn't really care that the law was very long and complicated. I think Representative Simon said it very well. We've gotten past this is a complex law. If you have to add a few pages and it can be clearer, that's what all of our goal is. The biggest change we are making is to amend the definition of an individual from natural person to pull the rules to be a living human being. We have special protection for people who are dead, data on decedents. We also amend the definition of person what we're seeing is that throughout the Act, many people have drafted these provisions, and they use person the way normal, regular people will use person. And if you look at Section 33, which is about tuberculosis, as far as I know, businesses can't get TB, at least not yet. So we're making those corrections to the various provisions where it looks like you meant an individual human being and not the broader business, other kinds of entities. Next up, we also, in Section 12 of the bill, have changes to who is the default responsible authority in political subdivisions. Right now, in cities, counties, townships, school boards, certain townships, not all, the governing body is supposed to appoint an individual to take data practices requests and be the responsible authority. What we hear from our citizen customers, especially for some of those small organizations, the government hasn't done that. So there's no one for them to make the request to, so they kind of go around in this circle of there's no one to ask, how do I get data? So what this will do is specify certain individuals in each political subdivision to serve as the RA, responsible authority, until the governing body appoints someone else. So this is really just a placeholder. Many governing bodies have already made this designation by resolution. We just want to make sure there's always a default if they haven't done that. We have had feedback from the County Attorneys Association and others, folks who are a little concerned that the county attorney perhaps shouldn't be the default. Our thinking, this idea came from some stakeholder feedback we got, is the county attorney is really the best person to at least make sure that this job gets passed on to somebody else. So if anyone has better ideas for how to address that, we just want to make sure that a citizen always has someone to make a data request to. In sections 13 and beyond, around summary data, we are pulling key provisions from the administrative rules that were last updated in the early 80s. Rulemaking is expensive. Slowly, what the division would like to do is pull the rules into the statute to bring them kind of up to date, make them a little bit more tighter and concise. The rules also only apply to data on individuals, so living human beings, and not all the data. And we had an advisory opinion several years ago that basically said you can only have summary data when you've got only data on individuals and not a mix of individuals and businesses. So we're trying to make that happen. Section 14 and 123 of the bill, we pull all of the government entity obligations into one section. Right now they're sprinkled, kind of hidden in a couple different provisions. We just want one place where your data inventory and your public access documents and procedures, so that we can easily point people and use it as a way to highlight this responsibility for people, since they, even though there's been lots of training going on since 1974, there are still government entities where they're like, I'm supposed to do that? Really? So we just want to make sure that everyone knows they exist, so we're going to put them all in one place. Section 16 of the bill addresses the sharing government to government of geospatial, GIS data. We have heard some feedback on there might be a need to define what GIS or geospatial data means. What we have here is there are already existing provisions in law where a government entity can recoup their development costs and charge a commercial value add-on. So we have government who won't share with another government because they don't want to lose their revenue stream. So they work on lengthy agreements to say, if I give you this public data, make sure you're not going to give it to anyone else. So what we allow is government to government, this data can be shared. This comes from one of my units is MinGeo, which is moving over to OET. The GIS community is very supportive of making sure that for emergency planning and for all other purposes, government to government, they can make sure that they have this data. And that it also allows them to share it without liability. Everyone's always concerned, if I give this to you for free and there's something wrong with the data, am I going to get sued? So it incorporates that as well. Section 17 of the bill is around judicial traveling data, and this makes it clear, this language went in a conference committee, and Representative Holberg and Representative Simon might remember this. It went in a conference committee at the last minute, and it was to address those situations where something comes over from the courts. So my best example is we've got judicial branch people who park in the admin parking ramp. Their data is going to be would be presumptively public because they're not our employees. This would allow, if the judicial branch protects that data, the government entity who gets it can protect it as well. But what we didn't mean, and this tries to fix, is there's lots of stuff that's public in the courts, and when it comes over to, a criminal complaint, going to be public at Ramsey County, if it comes over to my personnel file, it's still going to be private data, so that the courts are not going to undo all the classifications that the legislature has passed, but that we can protect some data that the courts protect. So hopefully this gets at what it's intended to, but we're, as Representative Scott mentioned, continuing to work with stakeholders to figure out, kind of, is this the best fix to address the problem? Section 18 is around data challenges and appeals. And just to make it clear that a responsible authority has to make a written determination around an appeal, that's required, and then also to reduce the amount of staff resources that are consumed by inappropriate data challenges where, say I'm a doctor and I'm being, I've violated my license in some way. This is not the procedure for me to say, I don't like that you've stolen my license away from me. This is about the accuracy and completeness of data. So you can't challenge the policies, the procedures of a government entity. It has been the practice of the department around this, and some of the feedback we said, well, of course people can't do that. Well, we want to make it clear for everyone who reads this, as well as new employees who have to apply this, that it isn't about how I've been charted at the Moose Lake facility. It's really about the accuracy of data. It also provides that the commissioner can maintain data as a part of an appeal classified in the same way as it would be in the government entity. What we typically get is a citizen gives us a copy of all the records, and coming directly from the citizen, it would be presumptively public, and we don't think that that was the intent. We want to be able to protect the data, even if we haven't gotten it directly from the government. Section 29 is around security information, and I know that this has been an area that has gotten lots of interest. This doesn't address many of the conversations that have been going on. What this provision does is to require that the person who makes the decision, the individual who makes the decision around security information should be the responsible authority. And it's not going to be a line staff person. It's really going to be the person who is the head of data practices for that government entity who makes that kind of a big decision, that it's not a line staff. But that it also, we have a best practice that we encourage people to do, is if you're going to deny someone access because of security information, give them a short description of why. Like, if I give you the passwords, you will hack my system and you will steal the state's money. Makes sense to me. It's not like the description doesn't have to be super long. It's typically a couple sentences as why is this security information, so that the person can understand why it's being withheld from them. We think that is really good for citizens to be able to have some kind of a rationale from their government when they use this. But we certainly understand that many people are concerned that security information might be being used more often than it has been in the past, and that on the policy question you may be looking at amendments or other bills at some point this session to address that piece. This just does one little best practice, make the government have a requirement to actually give the person some kind of documentation on why. And we think that's a good thing. The provision on civil investigative data in Section 38 is, what we have is someone makes a data request, the government doesn't give it to them, and the person starts to say, I'm going to go higher up. I'm going to go to the Commissioner of Administration. I'm going to go to the Office of Administrative Hearings. I'm going to take you to court. And then the government says, if you're going to do that, I think I've got a pending civil legal action. And when the issue is only the timeliness of your response to a public data request, and then you throw the cloak of civil investigative data over the whole thing. We are working with stakeholders, again, to better tweak what this says, but that is the goal, to be able to say, if our only issue is how you've responded or not responded to a data request and there are no other issues, you can't use this broad discretionary classification for that data. On personnel data, which is sections 43 to 53, what we do is we had an advisory opinion from 2010 around current and former employees. And what this does is make sure we take individuals subject to this section so that each subdivision in personnel data applies to the same people. Because what we found is a number of them would say current and former employees or just employees, and it didn't say current and former employees, volunteers, independent contractors. So now we've got the same protection all throughout the section for all of those folks. We also remove local level elected officials from personnel data protection, so cities, counties, school districts. This will provide greater consistency. Right now, what we have is we have advisory opinions from the commissioner as well as the attorney general that says the government gets to choose. So a city, two cities can make different decisions. One can say, I'm going to protect my elected officials like employees, and the other one can decide they're not going to, and all the data is presumptively public. What we hope is that this provides a vehicle to have a conversation about what data should be protected around those local elected officials so that the same people will get the same answer regardless if I go to see this city, this school district, this county. And I know the newspaper associations and the leagues are working on what are the elements around these local elected officials that really need protection and some classification. In what way are they different from employees and have less expectation of privacy? And in what ways do they need more? Section 56 is on welfare investigative data, and originally as introduced, this talked about the rules of discovery for this confidential and protected non-public data. And now it will be available to a party named once it is filed with the court. So filed with the administrative law judge, filed with district court. So it sets a time frame on when that person would get access to it. Section 80 is around applicants for employment. For those of you who've been around for a while, the applicants for appointment to a public body used to be in 1343, and when we pulled them into 601, there were some elements of data that's always public about them that didn't get kind of copied over. So this adds to the list of public data about them to include first and last dates of service, existence of any complaints, and making the final investigative report around an investigation of a complaint about them public data. So this makes it better mirror those two provisions. And Section 110 is on inactive financial transaction data. And this idea came through us from the BCA and the Financial Crimes Task Force around the issues of identity theft. When a criminal investigation becomes inactive, the data is all presumptively public. And that would include bank routing numbers, credit card numbers, and other numbers that leave people even more open to identity theft if they haven't already. So they highlighted the need to protect that information and have it redacted in these cases. And if you wanted to talk about security information, I think that this is a way that on a daily basis, you probably have lots of law enforcement agencies already redacting credit card numbers and routing numbers using security information to protect this kind of data because they're like, I've already had someone who was the victim of identity theft. Am I really going to give you a copy of all their account numbers? So. And the last is Section 120 on the open meeting law. So I don't want you to think we've forgotten that. This change will clarify that the 10-day web posting for statewide bodies doing electronic meetings is only for regular meetings. It's impossible for it to be a 10-day notice for special and emergency meetings because those are laid out as meetings that need 3 days or less before they occur. So this was a floor amendment, so we just thought that this was what you intended, was it was going to be a web posting for 10 days for regular meetings. And I also wanted the other things that are in this bill from last year. You might remember that admin had a technical data practices bill that changed grammar and tried to change government data maintained. And many of those provisions were left out in civil law last year. And in the Senate, we addressed the concerns that were heard here in a different way. So this is something that is kind of up for discussion. It may stay in, but certainly if people have concerns about it. So what we did is pull the way the language was addressed in the Senate. Instead of shortening it up, we just inserted missing verbs. So it's government data collected, created, maintained, or disseminated to make it the laundry list so that all the same verbs are in all the sections. So hopefully to clarify things for people. Well, I am done. If there are any questions, I want to say we are really committed to we've been working overboard to try and get as much feedback and to try and make this as good as we can make it, and we've really appreciated everyone. It's always, when you have a hearing that comes up quickly, you're always like scrambling to try and get everything, but I will stand for questions. We are certainly hopeful that we can all do better to make this clear and simple for the people who need to use this, and we appreciate your support in that.
All right, thank you. We have about 5 people listed that also want to testify, but are there any questions of Ms. Byer-Kapinski or the author at this point? All right, well, stand by, and on my list I have Mr. Gemberling, and then next up Mr. Newmeister. Following that, Ms. Brace, Ms. Walther, and Gary Thaden. Mr. Thaden. Welcome to the committee, Mr. Gemberling.
Thank you, Representative Holberg. My name is Don. My last name is Gemberling, Gemberling, and I'm appearing today on behalf of the Minnesota Coalition on Government Information, sometimes known as MINCOGI. MINCOGI is a 501c3 nonprofit organization composed of librarians, lawyers, citizens, media people, journalists, whose basic objective is to try and assure that government information is available to the public whenever possible. So, a couple of years ago, given a legislative activity, MINCOGI decided it needed a spokesperson to come here, and they picked me basically for 2 reasons. I'm mostly retired, so I can't get in trouble with my boss, and I know something about the topic because I've worked with these issues for about 40 years. So, what I'm going to tell you today is pretty much been summarized in some written materials we've submitted to the committee, and so I'll just try and be brief. To give you what I think of as context, for lack of a better word. One of the things I've learned is that when you do things to the Data Practices Act, when you make amendments, you may think that the amendment is something small, technical, and inconsequential, and somehow it comes up in a court case and it turns out to be not so small and not so consequential, or inconsequential. That's, I think, a large part, a function of how the Data Practices Act tries to deal with all these issues at a very detailed level. That's been an ongoing discussion for years as to whether or not you should be doing it that way. Suffice it to say that's the route you've taken and that's the route you continue to follow. But having said that, I think it's important that you look very carefully at what may appear to be technical changes, okay? Because they may turn out not to be technical changes. And this bill has a lot of technical changes. And so, to give you a hint, give you kind of an idea, the definition of person in the Data Practices Act is based on the same definition in the Statutory Interpretation Act. I'm going to guess that definition has been in the statute for about 30 years. Okay? My understanding of why a change is proposed in using the word individual instead of the word person in a number of places in the Data Practices Act is because the current language produces confusion. And frankly, I'm confused by that description because, as I've said, this has been the way things are for a number of years. And if there's any confusion, I'm not quite sure whether or not this fixes it or produces some kind of unintended result down the road. I'll give you an example. In one of the bill's provisions is introduced, there is a misdemeanor penalty for a violation of the Data Practices Act. And in the bill as introduced, the word person was changed to an individual. Well, in the history of the Data Practices Act, part of what the legislature wanted to say was if persons violate the Data Practices Act, companies, for example, they should be just as guilty as an individual for a misdemeanor. So by changing that term, you've changed previous intent. And I think that's part of what you need to understand with a number of the proposed changes. I'm just going to pick what I think of is the biggies. Ms. Byer-Kapinski has already indicated that some of the things that were of concern have been changed, like the 6-month limitation on the public getting access to data. So electronic geospatial information, or geospatial government data is the term used in the bill. That term is not defined, okay? And I think it needs to be defined. When we've discussed it, the definition seems to be GIS data, okay? And I think most people understand what GIS data is. But if you don't define it, whenever you don't define something here, you invite mischief, because suddenly things become electronic geospatial government data that nobody would ever have thought of. In my past life, I once had to staff a committee setting geocoding standards for the state of Minnesota. It's something I put real high up on my resume. I got to tell you, I spent a goodly share of my time after those meetings going back to my office, getting out my dictionary and looking up terms that geocoding people understood, but I was like, what is this stuff? So clearly that term needs a definition. But in the language associated with it, this is a continuation of a very old fight. Many years ago, Hennepin County came to you and they said, we're developing a lot of electronic information systems that have commercial value. And we want to be able to copyright those systems and sell them to the public. And there was a considerable discussion about whether or not that was a good idea. And what the legislature settled on is that you would not allow them to copyright things. You would allow them to recover the costs they incurred in developing those systems, okay? Which at the time seemed like a reasonable compromise. Now, Hennepin County got creative after that point and decided that recovering development costs means recovering all the ongoing costs of running the system. Some of us have trouble with that, and particularly the media community in Minnesota has trouble with that. But if you want to challenge that decision, of course, you have to sue Hennepin County. And now you're talking about going up against one of the biggest governments in Minnesota in a lawsuit. So nobody's ever been willing to do that. What the bill does is to say that if Hennepin County, for example, sends its geospatial data to some other county, and let's say Dakota County, and I go to Dakota County and say, I want to look at that data or I want a copy of it, they send me back to Hennepin County. Now, it doesn't say that, but what that means is, in legal terms, is they've copyrighted the data, okay? Because they're controlling its use wherever it goes in the state of Minnesota. So, and I think, you may want to do that. You may want to let local government in the state of Minnesota make money off databases and that kind of thing, but that does take you to a place where the implications for the public are very extensive. In the section that deals with data challenges, and this is a discussion that we keep having with the folks from IPAD, what the language says is, part of the language, is that an individual can't challenge the policies and procedures of a government agency. Well, there's nothing in the existing Data Practices Act that allows them to challenge policies and procedures of a government agency. Now, do they try that? Yes. The appropriate response from the government agency ought to be, you can't do that. And as a matter of fact, there was one government agency that did allow people to do that, and then the Department of Administration, when I was working there, would get these data challenges involving policies and procedures that had nothing to do with what the statute allowed an individual to do. So we would send it back to the individual and say, you can't do that. Well, the response was, this other government entity told me I could. Well, I don't see how this fixes that problem by putting into statute language that says you can't do something that you can't already do. So to me, it's just confusing and unnecessary. IPAD has discussed moving rule provisions into the Data Practices Act. Okay. When the legislature enacted the Data Practices Act back in the mid to late 70s, part of what they did is they authorized the Commissioner of Administration to promulgate rules to implement and enforce the Act. Now, the idea with those kind of rules was, do you want to put a lot of detail into the statute? And at the time, by the way, the Data Practices Act was 12 pages long, so it wasn't very big. The rules, when promulgated, were longer than the statute. But the idea was avoid putting detail in the statute, leave it up to an administrative agency with some expertise, as long as you don't trump on what the statutory authority is. And so those rules were promulgated in 1980, and they have not been changed since then for a whole variety of reasons. However, they're still very helpful in guiding people as to detailed questions about the Data Practices Act. Now, we have a basic difference of opinion with iPad. iPad says nobody complains about the size of the Data Practices Act, which is just astounding to me because everywhere I go, people just complain about the size of the Data Practices Act. I didn't bring my copy up with me, but it's, as you all know, it's well over 120 pages long. So the idea of removing the rule provisions into the statute, okay, if you want to do that, fine, but you're going to really end up with a much bigger statute. However, if you do that, as is done in this bill with one rule provision, make sure that you move the whole rule provision if it's worth moving. And what's proposed here does not move the entire rule provision. It only moves part of it. And I'm not quite sure why that is, okay? The rule provision that was promulgated, that language was put there for a reason. I spent roughly some part of 3 years of my life doing those rules. Spent a whole day sitting in that room 10 with 112 attorneys for government agencies. Went through 4 reviews of the Attorney General's office. As you can see, these rules had some attention. And 2 reviews by the Chief Administrative Law Judge before they were finally adopted. So I kind of think maybe we got them right, but that suggests that if you're trying to help people understand the Data Practices Act and you're going to start doing things with the rules, make sure you look at the rules clearly and take what's there if it really needs to be there. The security information provision. What has happened in the last 4 or 5 years is that the security information provision is being used in all kinds of situations in which many of us, particularly those of us who know its history, think are totally inapplicable. And increasingly what it's being used for is to deny the public access to data that you have clearly said is public. Okay? So government agencies are taking a general provision and using it to overcome a specific provision. Now, if that doesn't sound like a violation of the Statutory Interpretation Act to you, then we can talk about that. But again, keep in mind, the only enforcement mechanism you have in the Data Practices Act, beyond the Commissioner's opinion, are forms of lawsuits. You can go to district court or you can go to the Office of Administrative Hearings. Both of those routes require expense. So whenever you have these creative, for lack of a better word, interpretations, like applying security information to the names of employees who continued to work during the government shutdown, or to public law enforcement data, such as what happened in a store at the Mall of America, I'm going to suggest to you that that is not a proper use of the security information provision. So what you have an opportunity to do, because the security information is in the bill, is to fix that. Okay? In addition, there's an advisory opinion of the Commissioner of Administration involving the construction of a new headquarters for the Planned Parenthood organization, which says that any and all documents in the hands of the City of St. Paul associated with the building of that building are not public. Now, I can understand, given the kind of building it is and the contentious issues associated with abortions, that you would want to have some security features of the building and that sort of thing not available to the public, but not all documents associated with the building. Okay? So, what's proposed in the bill is fine. I don't think it accomplishes anything. As I told Representative Scott this morning, because it requires the government agencies to give some explanation as to why they're calling something security information, what will happen is the government attorneys at CLEs will come up with boilerplate language and teach each other what the boilerplate language ought to be. And why do I say that? Because I used to teach at those CLEs and listen to those kinds of things. We continue to have concerns from COGI with the personnel data stuff. We understand what they're trying to accomplish. We're just not sure it goes far enough and whether or not it will really get to what they're trying to do. So I suggest you look very closely at that. There's some other provisions in here that are, for lack of a better word, kind of esoteric. And as I said, I've directed a memo to Representative Scott and other people, and I suggest you look at it closely. Now, what was new to me when I arrived today was the grammatical and other kinds of stuff where we're once again doing data is or are and using the term government data sometimes and not others. And that's one of those where, again, it's technical, but be careful. And my problem is it's not consistent, okay? Sometimes the proposed bill uses the term government data, and other times it says government data, including data created, collected, used, maintained, or disseminated. And it's those kind of inconsistencies that I think the courts sometimes look at and say, well, if they said it here and they didn't say it here, it means something, okay? So be very wary of that. I think there's a very simple fix, and that's use the term government data with a little bit of refinement as to how it's defined, and it is already a defined term in the Data Practices Act. And just use that throughout the statute and don't use all of that other stuff. I even found a section in which within the section it's used two different ways. Let's see, a section dealing with Attorney General data, which is really going to give somebody a clue that there's supposed to be some different treatment given the difference in the definition. Because in the Data Practices Act, the definitions are really what drive the statute. They're the things that people look the most closely at. In closing, a long-term legislator, some of whom you probably all remember because a lot of you weren't here when he was here, Jack Davies, who was the president of the Minnesota Senate. Jack was also a scholar of the legislative process. And he wrote a book called Legislative Law and Process, which I recommend to everybody. It's a very nonpartisan book. Lay people who've never dealt with the legislature read it and go, oh my God. Because he says things like, you never make bad decisions. You only make bad decisions when you get bad information. And I remember when we talked about that in the legislative process class at Mitchell, you know, there were about 10 of us who worked with the legislature. We were all sitting around going, and everybody else was going, you know. So, why do I mention Jack's book? Well, Jack has a concept in his book that he calls the hairy arm. And the hairy arm, particularly in very large bills, is that thing that everybody focuses on and says, oh, this is really awful. We got to do something about this. And meanwhile, this other stuff is just slipping through because all you did was look at the hairy arm. Now, whether or not there are hairy arms in this bill, I can't tell you. But I really urge you to look very closely at the provisions of the bill. Think about what they do out in the real world, particularly in a real world where the more that MNCOG sees is government trying to find more and more ways to deny the public access to government information. If you got any questions, I'd be happy to answer them, and thank you.
All right, thank you. Mr. Gemberling, I think it will keep moving on with testimony. We're going to be done by 2:15 today, so if there's time for questions at the end, otherwise this is being laid over, and you all know where to find us. Mr. Newmeister.
Madam Chair, for the record, my name is Rich Newmeister. One of the things that we've all learned is words mean things. Particularly in the Data Practices Act, words mean things and can be literally used to deny people access to information, public or private or whatever. What I want to do is just go through the bill very quickly. Some of the concerns have already been raised about the definitions previously by Mr. Gemberling, particularly the individual person. On page 3, when you talk about the responsible authority, if you're going to adopt that section, it should not be county attorneys that are, you know, for counties.
Madam Chair?
Mr. Sana.
Just a question for Mr. Newmeister. Are you talking about are you pegging your comments to the DE amendment or to the original bill?
Yes.
Okay.
On the DE amendment, there's a conflict there. I mean, I can see sort of like a county attorney, well, and who also at the same time has to do some other decisions. Again, this is one of the interesting things about words. I'll look at summary data on section 13. Basically, you're taking out data on individuals for summary data, but you then put not public. You go to the definition of not public includes non-public, which then also in the term non-public means data not on individuals. So the issue is, would this new summary provision apply to data not on individuals? Be basically, again, it's just one of those things that I'm just trying to share with you how words mean things or definition of mean things and what the impact is on that. In regards to the whole issue of the summary provisions, if there's going to be a move forward to go towards this, I would like to see some changes in the language because it was done 80 years ago. Summary data is much easier to get now with computerization of information and all that. And so there could be some changes in there. On page 4, lines 417 through 423, I would encourage to reinstate that language. This is one of the very important parts. Right now, currently, by August 1st of each year, and it was timed because the legislative session ends in May, whatever changes there might be as it relates to public access to information, they do it with their procedures. You take this mandate out, there is no enforcement mechanism. And a lot of agencies do comply, and I have seen over the years, August 1st is when they usually put those things in. It's just, I think, a very important thing for the public. Now, when we talk about geospatial, I'll use an example. Let's say in the St. Paul paper yesterday, they talked about the Frogtown area. And if you go, they use census data, they may use some other kinds of data, but what happens a lot in this GIS data, let's say a great big database with information from the health information for that community, Frogtown, maybe from the Department of Health, maybe from some other public entity or agency. There might be some other kinds of information. So for the public and for policymakers, this is a great piece of information to give you a profile or certain information about a community in which you live in. How I see this language is, let's say, for example, Ramsey County contributed some information for this geopolitical social map. Well, it seems like that, it's done by City of St. Paul. The City of St. Paul is going to ask Ramsey County, hey, can we give this to Rich Newmeister? And then the government entity, no, you can't redistribute it, for whatever reason. I just say that this is some issues here. And so, and as we go down this pike, I think there can be just a review in how we can make this kind of stuff more freely available to the public. Our talks have already been on the challenge issue. Section 23 on page 9. Mr. Gemberling talked about it, but it says where the penalties is. You change it from person to individual. That's an example. That would be on page 9, section 23. That's where at least words change and may mean something different. Security information. One of the things that I did, I asked for the names of the construction companies that were doing the Planned Parenthood. Basically, it went through the Department of DIS, which is their licensing department. It went to their city attorney, said, no, we're going to call it security information. So who determines or who is liable for determining, I don't know. And if I wanted to do something about that. I think there can be some additional language on the security to emphasize more accountability. I'm just going through real quick here. Now, the thing that's kind of interesting is about the 1343 section is that if you take a look, it says number of the employees is being written out and the word individual. So this comes to the issue, who is really subject to 1343? And where it says specifically employee, it's an employee of a public entity. How volunteers and those folks fit into this, I don't know. So I don't know when you take away the employee and put individual subjects, do you expand it? And like on page 17, the question I have on 1713, I just put a little thing here, may impinge on what is now public, which could be less public. On page 18, one of the things, this is an interesting thing, is that many years ago, what was happening is people were appointed, like commissioners and folks like that, were appointed, and there was an investigation done on them, and they would resign immediately, and then all of a sudden, you could not get any access to any of that data. Why? Being investigated. And it applies only to state entities. But one of the things that they take out here on section number 2, 1814 and 1815, it says members of boards or commissions required by law to be appointed of the governor. So I'm curious whether or not that's an exclusion from that law. You know, if we want to do some positive things, that we could include this on for local political subdivisions and school districts. That would be a great positive thing for public openness. The one thing that I want to be able to talk about is on 1346, which is on page 27. One of the things that, this is an important item, I think, is that there are many people who come under DHS. You have individual people, licensing people, and all that. And one of the provisions in there is that if you are named as a party in a civil criminal proceeding, administrative, or judicial, you can be, for preparation of defense, you can get access to that information. It's very clear, and it's confidential if you're subject. But now, putting in upon filing with the court, I believe that becomes a barrier. So, Madam Chair, members of the committee, other points have been brought up. I'm sure this will be an continuing thing, but I just wanted to highlight to you some things that either should be taken out. That one I just talked about, 1346, I think should be taken out.
All right.
Thanks very much.
Thank you. Ms. Brace. Welcome to the committee. State your name for the record, please.
Thank you, Madam Chair, members of the committee. My name is Twyla Braze. I'm president of Citizens Council for Health Freedom. And there's been a lot of good comments made already by the previous testifiers, and I'll try not to duplicate them. I think one thing I'm just going to say is that we're looking at the DE amendment, DE1 amendment, and we counted to see the difference between the original one and the DE, and there's 73 new sections. 73 new, not like section numbers, but sections that are highlighted by the, by the bold title. So there's a lot of information in the DE1 amendment that I haven't been able to even look at to see, what it means. But I will say that I concur with the idea of moving to changing the definition of person, changing the definition of individual. The definitions are key to the Data Practices Act. And when you look at some of the language, I know that Ms. Kopinski said that these are technical changes and they're just trying to unify it. But it's very interesting to look at the places in the bill where it adds the words created, maintained, used, disseminated, and there's another one too I just can't think of. But there are other places where it takes it out. And one of the things that concerns me is that if you look at some of these statutes having to do with data in other parts of the law, it will talk about, data is collected, blah, 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 right? But then if you're going to make all data to be data that is collected, disseminated, used, et cetera, I'm concerned that there are new powers being given to the data, that there are new powers over which we will not know, not just data that's collected, but what have they created from the data that's collected that we may not have access to as a result. What kind of new powers will they have to create or to disseminate it, and then to have those protections when it's disseminated that we can't then get access to it? I'm uncertain, but what I do know is that these are a lot of new terms called technical, which are likely to not be so technical. The other thing that I would say is I'm going to also talk about the geospatial and say that I know that the Health Department and the Department of Human Services are doing geocoding, looking at areas, and if that information cannot be accessed by the public, which it seems to me in the new language that it couldn't, we would not even be able to know how they got the research statistics and the data that they talk about, because we would not be able to see the kind of information that they got. So I think that's a big deal, and I think that it should have a definition. But I think it's a big deal to do that kind of limit on the public, where it looks like only the government gets to decide who gets it. And then I would say there are a lot of things that are concerning about this bill, and a lot of them have been mentioned, so I'm not even going to talk about those. They include the security. I'm concerned about terms like reasonable value, reasonable cost. I'm concerned about the brief definition that you get. I agree it's going to be boilerplate. The penalties on the individual, when really today it's on corporations, but this would really just be on the individual within the corporation. And one thing I would add is that there's this 30 days in which the agency has to reply as to when summary data has been asked for, and they have to either give the data or they have to say why, and they have 30 days to do it. I don't believe the Data Practices Act has a limit for any other data. So like I've asked for a lot of data from different agencies. There's no date by which I believe that they have to provide it for me or this. I think probably if there were a good statute for the department to do, it would be to have that kind of a requirement for other data, not just summary data. So thank you, Ms. Madam Chair.
Thank you. Next on my list is Ms. Walther from the Police Officers Federation of Minneapolis. Welcome to the committee. If you'll state your name for the record, please.
Thank you, Madam Chair. Ann Walther, representing the Police Officers Federation of Minneapolis. And I just have two things that I would like to bring to the committee's attention. The first is, when I was reading over the original bill and then now the DE version, there was an addition, and this is referring to Section 44, which is amendments to 1343, the personnel data section. Subdivision 2.5 adds to the final disposition of any disciplinary action together with the specific reasons for the action and data documenting the basis for the action, adds excluding private personnel data about other individuals subject to this section and any not other public data. Now, what was removed was a change that was to D that talks about a complainant having access to the complainant statement, and it said that that would be, the complainant's identity would be private data. Now, that's been changed, but that brings to our attention something that has been a concern for the unions that I represent, that different cities interpret, I think what I would guess is the administrative decisions that refer to employees who provide information in an internal investigation where they're not the accused, they're just either a witness or the complainant. And the Department of Administration has said that that's private personnel data on those people. Although the way that the definition in the statute is, personnel data is data collected because you're an employee, and if you're simply a witness, you're not really there to provide information because you're an employee, but because the accused is an employee. What some cities are doing is that when an employee asks for their investigative case so that they can either present at a Loudermill hearing or at a disciplinary hearing in arbitration, they get a redacted investigation, so they don't know what actually was said against them, because the city takes the position, whatever city it might be, some cities take the position that the witness's data is data on them, not on the accused. So this has been an ongoing issue for us, and we would like to see an addition to 1343, which would be, I believe, a new subdivision that would say that would clarify this issue for good, that after an investigation into any complaint or charge is complete, an individual subject to this section, or if we maintain the way that it says now, an employee, is entitled to have access to and a copy of all data collected and maintained as part of the investigation into any complaint or charge against the individual, except as provided in Subdivision 8 of this section. And Subdivision 8 is the provision that already allows that in harassment situations right now, sexual harassment, the bill would expand that to any kind of harassment. The information can be withheld from the accused, except in a disciplinary situation. So again, I think that tracks, our recommendation tracks well with the language of Subdivision 8, which already takes into account that you should be able to get an investigatory file unredacted if you are the accused.
Representative Simon.
Thank you. Question for Ms. Walters. So are you saying that right now under current law, it might not be until it gets to a higher level, not just an internal investigation, but something higher, that the accused has any information about who the accuser is. Is that
Madam
what you're
Chair,
saying?
Representative
Ms.
Simon, that is what has happened. We've never gotten to a point yet where a city has refused to provide it even in an arbitration. But if they're taking the position that the data on the witnesses is private data on them, then technically they should never release it, which would obviously violate the due process rights of the employee, and I think violate PELRA if you're a union employee. So we've never gotten to that position, but I have definitely had situations where the city won't release the files prior to an investigatory, like a panel hearing or a Loudermill hearing. And really, you're at a point where, well, it's like, well, how do I defend myself if I don't know what was said about me?
Madam Chair.
Representative Simon.
Or by whom, really? That's the issue, right?
That's one of the
by whom.
issues. Yeah, it could be any number of things. It could be the witnesses' names, but also the information that they provide.
Okay, so, Madam Chair.
Representative Simon.
I'm sorry, I just
No,
want to
no,
make
that's
sure I'm
fine.
understanding it. So what you're saying is that under some interpretations, there are government entities who are saying that when the accused makes the accusation, it's data on the accused. I'm sorry, when the accuser makes the accusation, it's data on the accuser.
Madam Chair,
That's what you're
Representative
saying.
Simon, that's correct.
Okay.
And the witnesses as well, not just the complainant, but a witness who is a non-accused. And then the other...
Madam Chair, if I could,
Welcome to the committee, Mr.
Madam
Rice.
Chair, Brian Rice, Police Officers Federation. I'm really here just escorting Ms. Walther because she knows this stuff better than I. We do have some language that if the committee would be interested in, that we could circulate to the committee members and to the audience, if that's permissible or suggested.
Certainly, that would be just fine, and as you probably are aware, we're going to lay this all
Okay.
over, and we'll let it kind of simmer and have opportunities to have discussions with people that have expressed concerns, and
I think this was drafted to the original bill, but just so it might help
all right,
your
thank you.
staff or members of the audience if they've got concerns.
Thank you, Mr. Rice.
And Madam Chair, the other issue is when I wear my other hat, which is sometimes I represent public employers, and in Section 80, there are changes to Subdivision 3, applicants for appointment, and once the individual is appointed to a public body, this is under B, added are 3, 4, and 5, which I believe the person from iPad testified were intended to track the public data that's provided in 1343 for employees. There isn't a definition of appointed in the Data Practices Act, and for instance, the large employer that we represent, we have appointed employees and we have non-appointed employees. We have civil service employees. And we've always considered all of them to be employees under 1343, which would mean they would have the protection of the provision that says that only after a complaint has been sustained and discipline has been imposed does final disposition occurred. Under this provision, number 5, it says, upon completion of an investigation of a complaint or charge against an appointee, the final investigative report is public. That would mean it would be regardless of what the outcome of the investigation was, and that seems to be unfair to appointed employees versus what we have, which are civil service employees and appointed employees at what would be almost middle management rather than upper management positions.
Madam
right.
Chair, and I think on that
Mr.
point,
Rice.
too, thank you, Madam Chair, on that point, too, it does raise some of these issues that previous testifiers, Mr. Gemberling and Neumeister, raised about the definitional provision. You have an employee. Is there a difference intended between an employee and an appointed employee? And what is an appointment? Is it a civil service appointment, or is it appointment by, high-level confidential persons? I think you may be...
Well, and Mr. Rice, I think the section was trying to get at, like, appointments to planning commission and, so obviously, in your world, appointed means something completely different than, so we've got some work to do here, and that's not a big surprise. It
Right.
This usually happens with the data practices first committee, and most of us are used to this, so.
Yeah, is the appointment the chief of police, or is the, frequently in civil service laws, it'll talk about somebody is appointed, but that's the term of art, but not until after they passed the test or done something. So, and do you want to treat, the committee may want to treat appointed in the sense of high-level chiefs of police, fire chiefs, one way as opposed to all employees, or do you want to treat all employees the same? That's a policy choice.
I'm guessing we don't want to treat planning commission members like we treat chiefs of police either. Just a thought, but anyway, I think we have, if you've concluded your remarks, I think there's one additional person that would like to testify, and we've got about 6 minutes left. So, Mr. Thornton, if you'd like to. I'm sorry, Thaden, that's my trying to read without my glasses. My apologies.
No problem. My name is Gary Thaden, T-H-A-D-E-N. I represent Gopher State One Call. That's the entity that you call when you are checking to see if there's any underground pipes or wires and you want to avoid hitting those. We are a statutory-created nonprofit corporation. We are not a government entity. And I'm talking here about the geospatial data section of this bill, and it allows the sharing of this data at no cost to government entities, and we think we should be part of that data sharing at no cost. The only reason that we exist, the only reason we use the data is to protect the public and the underground facilities, and we think that we have a quasi-government policy that a quasi-government entity like ours should get this data at no cost. Thank you.
And, sir, do you currently get the data at no cost?
We get the data from some counties at no cost, and some other counties, the same type of data, they say we want lots of money, and we already have maps of areas, but this would add to our layers of information that we have, help out with county facilities such as pipes or wires that the counties may put in. It may help us with emergency response in case there's some type of hit to a gas pipeline. And so we think because we do this for the public safety, it would be good policy for us to get this data at no cost.
All right. Are there any questions for Mr. Thaden, who's brought us a new fun issue to ponder? All right.
To keep you awake.
Yeah, all right. Well, members of the committee, thank you, Mr. Thaden. We have about 4 minutes left. If anybody would like to wade into any questions at this point, we could certainly do that for a few minutes. Representative Simon.
Thank you, Madam Chair. There is one issue that I already talked about with Ms. Byer-Kopensky, so this shouldn't be a surprise to her, but I agree with something that Mr. Gemberling and others have pointed out, and I can't find it now. I think it's Section 23, the change from persons to individuals in terms of who is subject to the misdemeanor penalty. That's one where I'm certainly willing to listen, but I think to put it back the way it was, in other words, strike the underlying language, restore it, I guess it would be get rid of Section 23 would be my amendment. And Madam Chair, if you or Representative Scott would prefer that I not move that now and we do it at the next hearing, that's fine. But just to announce, I guess, generally that I don't think we want to limit the penalty to only individual people, because persons under the statute can be agencies too, and if a government agency doesn't give citizens something to which they're entitled, I think that agency should be on the hook as they are now and not just individual people. So I can either move in his amendment, but out of courtesy to the author or anyone else, if you're not comfortable with that, we can talk it over and then talk it about at the next hearing.
Now,
Madam Chair, I was just going to suggest, why don't we wait till the next hearing on this, and we've got it on tape, and I'm sure John will duly note that.
all right. First of all, Representative Simon, did you want Ms. Byer-Kopensky to comment on your concern at this point? Ms. Byer-Kopensky.
Madam Chair, Representative Simon, I want to let you know that, your feedback is very helpful, and the information you gave me about who can be subject to this, we are supportive of making that change to remove this section from the bill. I think that feedback from others, it makes a lot of sense.
All right, and if I might, Representative Scott, if we make the motion here today, then it will become part of the committee engrossment in the delete all ones, so when we would move forward we would have all of that in a committee engrossment for the next meeting. So it's really, it can be reflected for next time if you so choose
That's
that.
fine. Either way.
All right. Representative Simon?
Okay. I mean, then if that's the case, then I just wanted to give the author the chance. I wouldn't do it if she didn't want to at this hearing. But if she's comfortable with it, then I'll just move, my oral amendment would simply be to strike Section 23 of the bill.
And
As amended.
are there any additional questions from Representative Lesh?
Thank you, Madam Chair. So then, if an agency violates this, and it's a misdemeanor, is that a targeted misdemeanor where we'd have to get its fingerprints? I'll withdraw my question, Madam Chair.
Thank you. In
I'm
the
curious
interest
about
of time, we appreciate that. Is there anybody in the audience that would like to speak against the Simon oral amendment to delete Section 23 from the amended bill? Seeing none, all those in favor say aye. Aye. Opposed, nay. Section 23 of the delete all amendment is deleted. Any other questions or concerns? Representative Scott, could you let the committee members know about a timeline as far as another committee hearing? How much time people have to kind of work on these issues? A couple of weeks?
Madam Chair, thank you. Yeah, we'll probably work on this for a couple of weeks, so look for something down the road in about a 2-week time frame.
All righty, thank you. Any additional questions? With that, I will move to lay House File 2201 as amended on the table and move for adjournment.